When the company that made a chemical linked to Parkinson's disease settles a trial at the very last minute on the courthouse steps, that tells you something significant. It tells you the risk of facing a jury may have been too high. I'm attorney Tracy Paulsen with Rightful Legal, and today I want to talk to you about the latest developments in the Paraquat litigation and what this means for individuals and families affected by Parkinson's disease. Paraquat is a powerful restricted use herbicide used in commercial agriculture across the United States. It has been banned in more than 30 countries because of its toxicity, yet it remains approved for use here under strict regulations. Today, thousands of lawsuits have been filed alleging that long-term exposure to Paraquat is linked to Parkinson's disease. These cases have been consolidated into a federal multi-district litigation in the Southern District Court of Illinois. That means that claims from across the country are being handled in one court for coordinated pretrial proceedings. This process is designed to efficiently manage complex litigation involving similar allegations. Recently, the first federal Bellwether trial was scheduled to begin. Bellwether trials are test cases. They help both the defendant and the plaintiff understand how juries respond to the evidence and what potential verdicts may look like. But instead of going to trial just last week, the defendant settled on the eve right before jury selection. Now, this is very significant. When a corporation resolves a case after years of discovery, expert testimony, and full trial preparation, it's making an economic decision. It is choosing certainty over the unpredictability of a public jury verdict. In mass tort litigation, that shift often signals that a meaningful settlement is underway. So you can still qualify. So who qualifies? Individuals who work directly with Paraquat, including farmers, agricultural workers, pesticide applicators, and those who mixed or sprayed the chemical may be eligible if they were later diagnosed with Parkinson's. In some cases, people who live near treated fields may also have potential claims depending on their exposure history, or those that lived with someone who sprayed Paraquat. This is called secondary exposure. These cases require documentation of exposure and a confirmed Parkinson's diagnosis. They are fact-specific and they are time-sensitive. There are filing deadlines and there are statutes of limitations in order to bring a claim. And once a global settlement is structured and finalized, options can narrow greatly. That is why acting right now matters. At Rightful Legal, we'll help clients gather work histories, secure medical documentation, and evaluate whether they're qualified to participate in the ongoing litigation. We understand how multi-district litigations work. We understand how these cases are valued. And we understand how important timing is, especially in moments like this. If you or someone you love were exposed to Paraquat and later developed Parkinson's disease, you can call me directly for a free case evaluation at 617-821-5856. You'll speak with me, not an intake person or marketing company. We can help you evaluate your situation, explain your options, and help you protect your rights and hold the company accountable. When companies settle at the courthouse door, that's not the end of the story. For many families, it's the moment to step forward. I'm attorney Tracy Paulsen, and we're here to help. Again, you can reach me at 617-821-5856. Thank you.